Good evening, ladies and gentlemen. We have a very beautiful day here today, and we are very honored to have Mr. Edward Taylor of Shearman Sterling Law Firm with us here today to speak to us on the topic of Hong Kong's outcome-related fee structure reform, a win-win for arbitrating parties and their lawyers. Edward is a counsel in the international arbitration practice of Shearman Sterling. He is dual qualified in Hong Kong and England and Wales, and he is a fellow of both the Hong Kong Institute of Arbitrators and the Chartered Institute of Arbitrators. He represents and advises companies, states, and state-owned entities in a variety of commercial and investment treaty disputes, including, in particular, energy, infrastructure, joint ventures, post-M&A, and private equity. Edward is a member of the Hong Kong International Arbitration Center's list of arbitrators and the Law Society of Hong Kong's panel of arbitrators. Regarding the topic of tonight's presentation, Edward has written several articles over the past 2 years on the progress of Hong Kong's outcome-related fee structure reforms for publications including Asia Dispute Review and Clover Arbitration Blog. Edward also co-authored Shearman Sterling's submission to the Law Reform Commission of Hong Kong in response to the public consultation on the reforms. Now, during the presentation, may I remind the participants to type their questions on the chat box. You can find the chat box icon below the PPTs. We will answer your questions at the end of this seminar. And I'm also reminded by HKIArb that this seminar will be recorded. And for those who would like to watch this webinar again, they can visit the website of HKIArb. Now, without further ado, please join us in welcoming Edward. Edward, the floor is yours.
Thank you very much, Simon, for that kind introduction. And thank you, everyone who's joined this webinar. It's a real pleasure to have this opportunity to present to you on this topic. Now, as you'll have seen from this slide, the title of my presentation asks whether Hong Kong's outcome-related fee structure reform, which is due to come into force later this year, will be a win-win for arbitrating parties and their lawyers. And what I hope to show you in my presentation is that the answer to this question is yes, the reforms will be a win-win. And before we get into the presentation where I'll go through that in some detail, I'll make a couple of points up front to show you why I think the reforms are such a good thing for Hong Kong. The first is that other leading seats of arbitration, including London and most recently Singapore, already allow outcome-related fee structures. And those structures have proved to be popular with arbitrating parties. So Hong Kong's reforms, once they enter into force, should enable Hong Kong to remain competitive with those other seats of arbitration. The second point I'll mention up front is that Hong Kong's reforms should provide arbitrating parties with additional flexibility in how they arrange their relationships with their lawyers. And this is important because arbitrating parties are increasingly expecting the flexibility that outcome-related fee structures offer. In addition to giving sophisticated parties the access to that flexibility that they increasingly want in modern-day international arbitration practice, these reforms should also promote access to justice in Hong Kong for parties who would otherwise not have the funds to pay for a lawyer using traditional fee arrangements. And one point that I really want to stress here is that these reforms only provide parties with a new option, an alternative. They do not prevent traditional fee arrangements from being used if the arbitrating lawyers and their parties prefer. The third point I'll briefly make is that Hong Kong's reforms arguably established the most comprehensive and progressive outcome-related fee structure regime anywhere in the world. And this is consistent with Hong Kong's reputation as a leading innovative seat of arbitration. Now, despite all of those positives that I've just mentioned, that there are nevertheless some practical challenges and financial risks to be aware of when using outcome-related fee structures. So towards the end of my presentation, I'll cover those points as well. And the final thing I'll say before jumping into the presentation is that this topic invariably involves quite a lot of technical jargon and acronyms. And I've done my best to try and keep things straightforward and avoid using as much jargon as possible. But if I haven't explained anything clearly, then please let me know at the end, and I'll do my best to clarify. So in terms of the agenda for today's presentation, we'll start with a brief introduction to the three main types of outcome-related fee structures. We'll then take a look at the specifics of Hong Kong's reform, including the formalities that parties will need to follow when entering into these types of arrangements. We'll then briefly compare Hong Kong's reforms to the slightly more limited reforms that Singapore introduced a couple of months ago. And finally, we'll go over some practical considerations that lawyers should take into account when deciding whether or not to enter into an outcome-related fee structure with their client. So by way of an overview of what exactly are outcome-related fee structures. Now, outcome-related fee structures, which I'll refer to as outcome fees for shorthand in this presentation, comprise an agreement, a contract, between a lawyer and their client that conditions part or all of the lawyer's fee and sometimes the lawyer's costs on a defined outcome. So, to give an example, if a client agreed to pay their lawyer $1 million if they won an arbitration and nothing if they lost the arbitration, this would be a type of outcome fee structure. Similarly, if a client agreed to pay their lawyer 25% of any damages awarded to them in the arbitration if they won, and only pay their lawyer discounted fees if they lost the arbitration, that would be a different type of outcome fee structure. And to put it very simply, outcome fees are just an alternative to traditional fee arrangements like hourly rates or fixed fees. And as a general rule, we can say that the practical effect of outcome fees is that if a client wins an arbitration, they will pay their lawyer more than they would have done under a traditional hourly fee rate arrangement. And equally, if the client loses the arbitration, they will pay their lawyer less than they would have done under a traditional hourly rate fee arrangement. So that's just a general rule of thumb to bear in mind when you're thinking about outcome-related fee structures. And when we're talking about outcome-related fee structures, there are really three types we need to bear in mind. The first is conditional fee agreements, CFAs. The second is damages-based agreements, DBAs. And the third is hybrid DBAs, which are effectively a subset of DBAs. Now, these three agreements all share one key feature, which is what I described on the previous slide. They all condition part or all of the lawyer's fees and sometimes costs on a defined outcome, such as winning the case. But the key difference between these types of outcome fee structures is how the payment from the client to the lawyer is calculated if the defined outcome is achieved. For both DBAs and hybrid DBAs, if the defined outcome occurs, for example, if the client wins the case, the payment from the client to the lawyer is nearly always based on the damages awarded to the client. So the lawyer will be entitled to a share of the damages that the client won in the arbitration. CFAs are different from DBAs and hybrid DBAs because the payment to the lawyer cannot be based on the damages awarded to the client. And that's really a kind of regulatory restriction in many jurisdictions, or even if it's not a regulatory jurisdiction, it's just a sort of dividing line between CFAs and DBAs, that CFAs are not based on the damages. Instead, the way the payment under a CFA is calculated is different, and it will be defined in the terms of the CFA, but normally it will be based on reasons why outcome fees are interesting to clients. And for this purpose, we can split clients into two main categories: clients who have the capital arbitration if they want to, but they would prefer not to. And the reasons they might prefer to enter into the arbitration for the cost of the arbitration as they go is that the client might want to use the money they would have spent on the legal fees to instead pay for to fund their business. So they want to improve their cash flow rather than paying for lawyers during the course of an arbitration, which can take several years. Another reason that a client might want to use an outcome fee structure is to align their incentives with their lawyers. So in other words, their position is you, the lawyer, only get paid if we, the client, win. And the final reason is that the client might simply want to share the financial risk of the arbitration with their lawyer. And they do that because they don't have to pay all of the lawyer's fees if they lose. So those are the sorts of reasons that sophisticated clients who have the funds to pay for an arbitration but would prefer not to might choose to enter into an outcome-related fee structure. But there's also a different category of clients, which are impecunious clients who wouldn't have the funds to pay for the legal fees required to go all the way through an arbitration. So for those sorts of clients, these types of reforms actually perform a very important access to justice role by enabling them to get a lawyer and go through an arbitration that otherwise they wouldn't have the resources to do. Moving on to why outcome-related fee structures matter to lawyers. First, for the reasons I've described on the previous slide, there is increasingly demand from clients for these types of fee arrangements in numerous jurisdictions. And in my conversations with clients in Hong Kong, I know that there is also a growing demand for them here. The second reason is that outcome fees have the potential to make an arbitration more profitable for lawyers compared to traditional fee arrangements. So that's another possible incentive for lawyers. But I say that with a heavy caveat, which is that the flip side is also true. These types of fee arrangements introduce a financial risk by definition for lawyers, because under these types of arrangements, the risk of failure is shared with the client. So if the case is lost, the lawyer will nearly always receive less payment than they would have done under a traditional fee arrangement. And that's just part of the inherent risk sharing that outcome-related fee structures adopt. I'll make one other point here, which is that in the past, one criticism against outcome-related fee structures has been that they may incentivize lawyers to pursue vexatious claims. But the reality, and this is something that the Law Reform Commission mentioned in Hong Kong when they released their reports, is that the opposite is more likely to be true. And that's because outcome fees really encourage lawyers to pursue cases with good prospects of success, since their fees are dependent upon a successful outcome. So that criticism, which has been one that's used a lot in the past, is not really an accurate one. The third point I'll mention here about why outcome fees matter to lawyers is that they can enable lawyers to be more flexible when it comes to pricing matters for their clients, which ultimately can help lawyers to win more work from clients. And the fourth and final point I'll make here is that outcome fees can help level the playing field. And what I mean by that is, for example, Hong Kong's reforms should enable Hong Kong lawyers to compete with lawyers in other jurisdictions where outcome fees are already allowed. Because at the moment, you could say that Hong Kong lawyers are at something of a disadvantage compared to lawyers in other jurisdictions because they are unable to offer these types of fee arrangements, despite them being attractive to at least certain types of clients. And on that point about outcome fees becoming increasingly attractive clients, we can see on this slide examples of major dispute resolution hubs or seats of arbitration internationally who now permit outcome-related fee structures to be used. And this slide really shows that there has been increasing international acceptance of outcome-related fee structures over the past decade or so. And we can see that some jurisdictions allow CFAs, some allow DBAs, some allow hybrid DBAs, and some allow all of them. And I think one point to make here is that there was really a risk of Hong Kong being left behind if it did not introduce these types of reforms, given that nearly every other major dispute resolution hub in the world had already moved to implement these types of reforms. And that again was something that the Law Reform Commission noted in their reports. And this brings us now to the specific reforms that Hong Kong has introduced. And the starting point here is that historically, Hong Kong, as well as Singapore, have had common law rules of champity and maintenance in place that have prohibited third parties from having an interest in disputes. And this meant that both third-party funding and outcome-related fee structures could not be used in Hong Kong or Singapore. But in 2017, an exception was made to allow third-party funding in Hong Kong and also in Singapore. And in 2019, reform processes began to permit outcome fees in both Hong Kong and Singapore. And that process has led us to where we are now. So in August 2019, during the 2019 Hong Kong Arbitration Week, Hong Kong Secretary for Justice first announced that a subcommittee of the Law Reform Commission would consider reforms to permit outcome fees for arbitration. Just over a year later, the subcommittee issued a consultation paper in which they proposed allowing lawyers to use CFAs, DBAs, and hybrid DBAs for arbitrations. A year later, following a public consultation that many law firms and other interested parties in Hong Kong responded to, the Law Reform Commission issued a detailed report confirming its recommendation that lawyers should indeed be permitted to use CFAs, DBAs, and hybrid DBAs for arbitration. And since then, we've seen very rapid process, which I think just goes to show how committed the government is to maintaining Hong Kong's status as a major seat of arbitration. So in March, we saw the Legislative Council introduce a bill adopting the Law Reform Committee's recommendations. And here's just a picture from that bill, an excerpt from that bill. And most recently, at the end of last month, the Law Reform Committee's recommendations were implemented in the form of the Arbitration Legal Practitioners Amendment Ordinance 2022, which sets out the framework for these reforms. And what we can expect is that over the next few months, some subsidiary legislation will be put into place. And this legislation will flesh out the detailed mechanics of this regime before it ultimately enters into force by the end of 2022. So right now we have some of the legislation in place, but at least for the next few months, it's still not permitted to enter these types of outcome-related fee structures. But that should change very soon, and certainly by the end of the year. Now, if we look at the ordinance that's been put in place, we can see that it expressly provides that an outcome fee arrangement is not prohibited by maintenance of champity, which was a problem as we saw a few slides ago. And the ordinance also confirms that all three types of outcome fee arrangements I mentioned will be allowed: CFAs, DBAs, and hybrid DBAs. And the ordinance also set out some important details on who can offer outcome-related fee structures and what proceedings they can be used for. So outcome-related fee structures will be possible for barristers, solicitors, and registered foreign lawyers. All of those will be able to offer outcome-related fee structures to their clients. And in terms of the proceedings that outcome-related fee structures can be used for, it will be possible to use them for arbitrations in or outside of Hong Kong, including emergency arbitrator proceedings, court proceedings related to arbitration, so things like arbitrator challenges, enforcement of arbitral awards, and also mediation proceedings. So what this means in practice really is that parties will have a great deal of flexibility to use outcome fees for the whole life cycle of an arbitration, from its commencement, that may involve an emergency arbitrator proceeding, all the way through an arbitration, which may involve arbitrator challenges before the Hong Kong courts, up until the enforcement of an award once the award has been issued. So it's a really comprehensive system that's been established in support of enabling parties to have maximum flexibility to use outcome-related fee structures when they see fit. And moving on to now, I'll just, over the next few slides, talk through the three different types of CFAs. And on this slide, we have the ordinance's definition of of a CFA, a conditional fee agreement. And I won't read this out, but practically what this means is that parties can enter into two different types of CFAs. What can be called no-win, no-fee CFAs, and what can be called no-win, low-fee CFAs. And I should add that these terms aren't to be found in the ordinance, but they're just convenient ways of practically describing what these different types of CFAs do. So if we look at no-win, no-fee CFAs first, under this type of CFA, if the client wins, then the lawyer will get a benchmark fee, which is normally the fee that would have been due if the case had been charged on a traditional hourly rate basis. But on top of that benchmark fee, they'll also receive an uplift fee. And that uplift fee can be a fixed sum. So for example, it could have been agreed in the CFA that if they win the case, they get a 1 million Hong Kong dollar bonus. So you could have that kind of success fee arrangement. Or equally, it could be agreed in the CFA that if the party wins, then there's a percentage uplift on the hourly rate. So if they win the case, they get a 30% increase on the total amount of hourly fees that have been charged. But the flip side to a no-win, no-fee CFA is that if the client loses the case, the lawyer gets nothing. So to give us a practical example, just to sort of really hammer this point home, a no-win, no-fee CFA could provide for the lawyer to receive 100% of their hourly fee rates, plus an uplift of 20% of those rates if they win the case, and nothing if they lose the case. That would be a no-win, no-fee CFA. Moving on, the second type of CFA I've mentioned is a no-win, low-fee CFA. And under this type of CFA, if the client wins, it's very similar to what I just described for a no-win, no-fee CFA. The lawyer gets a benchmark plus an uplift fee. But the difference is if the client loses, the lawyer will get discounted fees instead of nothing. So and we'll come on to this in the final section of the presentation. But this no-win, low-fee arrangement tends to be much more favorable to lawyers because, one, for cash flow reasons, it means there's certainty because the discounted fee will normally be paid on a monthly basis. So the lawyers will be getting some payment during the lifetime of the arbitration rather than having to wait until the end of the arbitration to get the money, to get any money. And the second point is it also introduces more financial stability because the lawyer will have some certainty that they will at least get the benchmark discounted fee rather than nothing, which is the risk with a no-win, no-fee CFA. And although the ordinance that just came into force a few days ago doesn't contain an express cap on the maximum amount that a lawyer can receive under a CFA, it's very likely that the subsidiary legislation that I mentioned earlier will implement a cap later this year. And from the Law Reform Commission's reports and such like, it's very likely that this cap will be 100% of benchmark costs. And what this means is that if the benchmark fees were calculated on the basis of hourly rates, a lawyer could not earn more than double what the lawyer would have earned if the fees had been calculated on the basis of hourly rates. So if, for example, the lawyer, based on hourly rates, would have charged 1 million Hong Kong dollars for the case, under the CFA, the lawyer can't receive more than a total of 2 million Hong Kong dollars. That's the maximum cap. And the Law Reform Commission thought that was important to make sure that these types of arrangements weren't misused. And these types of caps are quite consistent with caps we see in other jurisdictions, such as England and Wales. Now, moving on to a different type of outcome related fee arrangement, and a very interesting one because it's something that Singapore has not introduced in its recent reforms, as we'll see in a few moments. So this is called a DBA, a damages-based agreement. And in some jurisdictions, such as the US, these types of agreements are called contingency fees. And under this type of arrangement, if the client is awarded damages, the lawyer will get an agreed percentage of the damages. But the flip side is that if the client is not awarded any damages, the lawyer will get nothing. So it's a kind of quite a risky proposition for a lawyer to enter into this type of arrangement, because it's effectively all or nothing. And that brings us neatly to hybrid DBAs. And this is a type of no-win, low-fee arrangement. And under this type of arrangement, if the client is awarded damages, the lawyer will get an agreed percentage of the damages. So if there's a win, the outcome is the same as if it was a DBA, which we just looked at on the previous slide. But the difference is, if the client is not awarded any damages, the lawyer will still get a payment. So the lawyer won't be left with nothing. And that payment will generally be a discounted amount of what their hourly fees would have been. And for hybrid DBAs, the subsidiary legislation that will come into force in a few months' time is very likely to set a cap on the maximum amount that a lawyer can receive if the client doesn't receive any damages. And that cap is likely to be set at 50% of benchmark costs. So what this would mean is that if the client loses, and by lose I mean the client doesn't receive any damages, the maximum amount that the lawyer could receive under a hybrid DBA is capped at 50% of the hourly fee rates they would have otherwise charged for the case. So if the case would have incurred hourly fee rates of 1 million Hong Kong dollars, the maximum amount under a hybrid DBA that a lawyer could recover if no damages were awarded is 500,000 Hong Kong dollars. So we've just talked about the caps on relating to a situation where a party receives no damages for a hybrid DBA. But there are also caps on the maximum upside that a lawyer can receive under DBAs and hybrid DBAs. And again, these are likely to be set in subsidiary legislation over the coming months. And these caps are expected to be set at 50% of the financial benefit obtained by the client. And normally the financial benefit will just be the damages awarded to the client. So if we take a practical example, if a client was awarded 10 million Hong Kong dollars in an arbitration, a lawyer could not receive more than 5 million Hong Kong dollars under a DBA or hybrid DBA, because the cap is 50%. If we now move on to a slightly different point, which is the recoverability of the costs that are paid to the lawyer under these types of arrangements if you win. So the question dealt with on this slide is, can a winning party recover the costs of an outcome fee arrangement from the losing party? So for example, if a CFA meant that a lawyer was entitled to 140% of the normal hourly fees, can that additional 40% above the 100% of normal hourly fees be recovered from the other side? And the general rule here is no. Parties cannot claim any uplift fees or DBA payments or hybrid DBA payments in excess of the normal legal fees that would have been charged if an outcome fee arrangement had not been used. However, there is an exception in the legislation, and what that says is that arbitral tribunals retain a discretionary power to award those costs where there are exceptional circumstances justifying the order of such costs. So one example we can think of here where exceptional circumstances might arise is if you had a situation where one party before the dispute or as part of the dispute behaved in a way that, for example, bankrupted the other party. And so the other party's only way of bringing the claim, because they didn't have any funds, was to enter into an outcome-related fee structure. So that might be a kind of situation where, because the conduct of the other party was so direct in requiring the claimant to enter into an outcome-related fee structure, that a tribunal might consider it appropriate to make the losing party bear the additional costs of that fee structure. And in terms of safeguards, the Law Reform Commission was very careful in doing its reform process to make sure that appropriate safeguards were put in place to make sure that clients knew what they were entering into. There were not going to be any nasty surprises at the end of the arbitration about how much money the client had to pay the lawyer as a result of the outcome-related fee structure. So there are likely to be various safeguards put in place, and again, those will probably be dealt with in subsidiary legislation or in professional guidelines that are issued to lawyers. But these include that the fee arrangement must be in writing and signed by the client. The client has to be provided with all relevant information about the fee arrangement by the lawyer. The client must have the right to seek independent legal advice. After the client has signed the outcome-related fee structure, there should be a 7-day cooling off period where they can change their mind if they want to. Disbursements must be paid irrespective of the outcome. And the lawyer should be entitled to terminate the fee arrangement if the client breaches it, the client behaves unreasonably, or there are any other grounds identified in the outcome-related fee structure agreement. And we'll come back to this later because this is actually a very important safeguard for lawyers and one that they should think very carefully about when they're entering into these types of agreements. And the other point I'll make here is that under this requirements heading is that if the ordinance provides that if a party enters into the outcome-related fee structure, they must disclose its existence or termination to the arbitral tribunal and the other party in the arbitration. And personally, in the various articles I've written about this, I've said that I don't believe this disclosure requirement is necessary, because these types of arrangement shouldn't introduce a conflict of interest that requires disclosure. And the reason I say that is that third-party funding agreements are required to be disclosed to the tribunal and the other party. And the reason for that is because of the risk of a conflict of interest given the involvement of a third party. But here that there is no third party, it's just the lawyer and the client. So I think an argument could be made that the disclosure isn't that there's not a real legitimate basis to require disclosure. But nevertheless, the decision has been made to require that in the ordinance, and I think it is a defensible decision. The other point to note here is that these types of fee arrangements are currently not permitted for personal injury cases. They're excluded under the ordinance. So one thing that's quite interesting to note is that as I mentioned earlier on, Singapore has also been looking in parallel with Hong Kong at introducing outcome-related fee structure reforms. And that's something you see quite often when Hong Kong and Singapore are looking to introduce reforms. They tend to sort of operate in parallel when looking at trying to safeguard their respective positions as leading seats of arbitration in the Asia Pacific. And what we saw is that Singapore introduced a reform which came into effect on the 4th of May 2022. And on this slide here, I've summarized the main differences between Hong Kong and Singapore's reforms. And in terms of the outcome fee structures that are permitted, Hong Kong's reforms are much broader in allowing CFAs, DBAs, and hybrid DBAs, while Singapore's reforms are currently limited to just CFAs. And I think what's really welcome about Hong Kong's reforms here is that it respects the freedom of contract. It respects freedom of contract and parties' autonomy by giving them and their lawyers the flexibility to decide whether to use CFAs, DBAs, and hybrid DBAs. And I think that's helpful because there may be some situations where it's more appropriate to use one than the other. So I think this flexibility that Hong Kong has decided to allow parties is a very welcome development that marks out Hong Kong's reforms from Singapore's. But moving away from the sort of practical benefits of this, I think there's also a more conceptual point, which is that once, and this is a point that the Law Reform Commission noted, which is that once you've crossed the Rubicon by allowing CFAs and third-party funding, there's no real reason not to allow DBAs and hybrid DBAs. You might as well just go all in and allow all of them. And it's gratifying to see that the Hong Kong legislature accepted that approach and has gone forward with that. And I think what we may well see in the next couple of years in Singapore, having read some of the parliamentary debates that happen in Singapore surrounding the reforms, is that they will ultimately move to allow DBAs and hybrid DBAs as well. The approach in Singapore seemed to be one of wait and see. They recognized that the DBAs and hybrid DBAs could well be useful to lawyers and parties, but they wanted to adopt a sort of wait and see approach. And interestingly, the Singapore Law Society were advocating quite firmly for CFAs, DBAs and hybrid DBAs to be allowed. So that could well be something we see in Singapore going forward. Now, in terms of permitted proceedings, as I've already mentioned, in Hong Kong, it's really, the focus is very much arbitration. So it is allowed in Hong Kong court proceedings, but only where they relate to arbitration. Whereas in Singapore, there's been a slightly broader approach, arbitrations, but also Singapore International Commercial Court proceedings that are unrelated to arbitration. In terms of cost recoverability of payments above what would normally be recoverable, we've already seen for Hong Kong that the uplift or damages payments are not recoverable absent exceptional circumstances. In Singapore, they've decided that they should never be recoverable. I mean, and personally, I'm of the view that that flexibility in the Hong Kong regime is welcome, because there may well be exceptional circumstances, like the one I described a few moments ago, where it is appropriate for the tribunal to order that the additional amounts should be recoverable as a cost from the other side. In terms of caps, as I've mentioned, it seems that Hong Kong will introduce caps. For now, interestingly, Singapore has not gone down the cap route. It may well be that over time they look to introduce them. But for now, there are no caps on CFAs. So in theory, in Singapore, you could have lawyers receiving very high amounts under CFAs, although obviously the amount that can be awarded under a CFA is something that will be negotiated with the client, and normally clients will be seeking to reduce the CFA uplift as much as possible. In terms of the calling off period, very similar. And in terms of disclosure, as I mentioned, in Singapore, they do need to be disclosed. In Hong Kong, they do need to be disclosed to the tribunal and the other side, whereas in Singapore, it's presently unclear. Okay, so I've spent quite a lot of time now talking through sort of the theoretical operation of these outcome-related fee structures. And what I'm going to try and do now is give some more practical insights into how these can be used in Hong Kong and the types of things that we as lawyers should be aware of when entering into these types of arrangements. And one important practical issue that I'll mention up front is whatever type of outcome fee arrangement is being considered, that the lawyer will often need to invest quite a considerable amount of time in investigating the merits of their client's case, because depending on how strong the case is, that may well inform whether the lawyer is prepared to enter into an outcome fee arrangement at all. And if they are so prepared, the types of terms that the lawyer is prepared to agree. So that's something to bear in mind, because it can be quite an expensive and time-consuming undertaking at the start of a case for a lawyer to do that type of factual investigation. And it can raise questions about whether the client is prepared to pay for that investigation if ultimately the lawyer decides not to enter into a fee arrangement and that kind of thing. So up front, that's one point I wanted to flag. Now, in terms of financial risks of entering into CFAs, on this slide, I've summarized the key differences from a financial perspective of the no-win, no-fee and no-win, no-fee CFAs that we described earlier. And from a cash flow perspective, a no-win, no-fee is quite difficult can be quite difficult for a law firm, because the lawyer is only paid at the end of the case if there is a win. And since arbitration cases can potentially take years, there's a long time when there'll be no payments coming in. So that might require, bank loans or overdraft facilities in order for a law firm to continue to fund its outgoings while the case is ongoing. In contrast, no-win, low-fee arrangements avoid that problem because the discounted fees will generally be paid on a monthly basis or however often the case is invoiced to the client. So there's a clear advantage there to no-win, low-fee arrangements. In terms of the overall financial risk, for no-win, no-fee, as the name suggests, if you lose, you're paid nothing. Whereas for no-win, low-fee, if you lose, at least you get discounted fees. So that's another advantage of no-win, low-fee. And in terms of the financial upside, it's completely down to the negotiation of the CFA or of either CFA. So it's not the case that no-win, no-fee CFA has a higher upside than a no-win, low-fee CFA. Both are subject to the same cap. Moving on now to comparing some of the financial issues of DBAs versus hybrid DBAs. It's very similar to what's on the previous slide because a DBA is a no-win, no-fee type arrangement, whereas a hybrid DBA is a no-win, low-fee type arrangement. So the same cash flow issues and financial risks apply. And ultimately, hybrid DBAs are going to be much more predictable for lawyers. There's going to be reduced financial risk since there'll be some payment, and there'll also be stable cash flow because payments will be made during the case. So typically, at least from the perspective of lawyers, hybrid DBAs are going to be much preferable. So, and this just really sums up what we've got on the two slides in terms of the relative risk profiles of these different types of outcome fee arrangements. And so on this slide, I've just given a practical example of a case where you might think about using a fee arrangement. So if you had a client who had a Hong Kong dollar 10 million claim, it was a very complex dispute, lots of fact witnesses, lots of contested points of law, and the client was requesting a 20% discount on hourly rates. This might be the kind of situation where it would be good to enter into a no-win, low-fee CFA. So the lawyer could agree that if the case is lost, the client will get the 20% discount on normal fees. But equally, if the case is won, then the lawyer will get a 20% uplift on their fees. They'll receive 120%. So that this is the type of situation where most lawyers, I think, because it's such a complex case, most lawyers will be unwilling to enter into a no-win, no-fee type arrangement, but they may well consider a no-win, low-fee arrangement. Now, in contrast, if we had a different type of case where you had, say, a $20 million claim against an insurer, and the dispute was relatively narrow, it was, say, a contractual interpretation issue, and the client wants to minimize upfront legal fees. This might be the type of case where a law firm would be willing, or a lawyer would be willing to enter into a DBA or a hybrid DBA, because the issue is narrower. It's easier for the lawyer to assess the merits of the case and get an overall sense of the likelihood of the outcome of the case. So where you have a narrower dispute, you may well see lawyers being willing to undertake sort of potentially riskier financial decisions with respect to entering into no-win, no-fee type of arrangements. And on this slide, I've outlined a few different ways that outcome-related fee structures could be used in practice. And normally, it wouldn't be necessary to adopt the type of sort of relatively complex structures that are described on this slide, but there may well be situations where a client demands it or it makes sense for other reasons. So the first example I have here is that you could have different types of fee arrangements for different phases of the arbitration. So for example, you could have a no-win, low-fee CFA for the jurisdictional phase of an arbitration if the arbitration was bifurcated into different phases. And then you could have a hybrid DBA for the merits and damages phase of the arbitration. The second point I wanted to mention is that it's possible to combine outcome-related fee structures with third-party funding. So if you had a very large dispute, for example, it might well make sense for a client to combine both third-party funding with an outcome-related fee structure with the lawyer. And the third point is that outcome-related fee structures can be layered on top of traditional fee arrangements. So say, for example, there was a client who was only prepared to spend a maximum of Hong Kong $1 million on a case. It could be agreed that traditional hourly fee rates will be used up to 1 million Hong Kong dollars, but any fees in excess of that are subject to a no-win, no-fee cap CFA with, for example, 100% uplift. So that's, these are examples of potentially creative ways that outcome-related fee structures could be used in practice. Now, just to close out this presentation, I wanted to highlight some risks that should be borne in mind by lawyers and clients when entering into these type of arrangements. And we've already talked about some of the financial risks relating to cash flow, so I won't go back over those. But there's another quite important financial risk, which is the risk that the outcome fee arrangement will be declared unenforceable by the governing court. And on this slide, I've identified an example from England, where an English law firm was required to return all of the legal fees it had been paid by a client because the CFA was held to be unenforceable by the court. And the reason why the CFA was held to be unenforceable was because under English law, like what we expect to see under Hong Kong law, the CFA success fee cannot be more than 100% of the benchmark fee. That's the maximum cap. But under this CFA, the maximum amount that the law firm could potentially receive was 280%. So the court held that this was unenforceable and all of the legal fees needed to be repaid to the client. And this really demonstrates the importance of ensuring that any outcome fee arrangement really strictly complies with the terms of the ordinance and the subsidiary legislation once issued. And finally, the final point I'll make, which is an important one, is that outcome fees have the potential to introduce real challenges to the relationships between lawyers and their clients. I mean, for example, what happens if during the arbitration, it becomes clear that the client has withheld relevant information from the lawyer? So you had a situation where the client was aware of some information that was harmful to their case, but they didn't disclose that to the lawyer at the time the outcome-related fee structure was entered into. And now the case is much weaker than the lawyer had understood at the time they entered into the outcome fee structure. And what can the lawyer do in that situation? Is the lawyer entitled to renegotiate the terms of the arrangement? Can the lawyer terminate the arrangement? And if they do terminate, what fees are they entitled to? And these are all sorts of issues that should be thought about at the time of entering into an outcome fee arrangement, because it may impact, for example, the type of termination rights the lawyer wants to include in the arrangement. And this is not just a theoretical concern. I'm aware of at least one major arbitration last year where the lawyers tried to renegotiate the fee arrangement a few days before a major hearing was due to take place, and the client took huge exception to that and effectively accused their lawyers of blackmailing them and wrote to the tribunal about it, and it created a big problem. So these are not hypothetical risks. But having said that, I think they can all be managed if the arrangements are properly negotiated and thought about at the outset of the arbitration. So I think we have about 10 minutes left, and I see there are already a few questions. So maybe I'll stop here, but I'll just make a quick conclusion, which is to say that hopefully you've seen from this presentation that the advantages of outcome fees really far outweigh the risks that I've just described on these last couple of slides. And all in all, I think parties in Hong Kong and lawyers in Hong Kong should be very excited about these reforms because they put Hong Kong on a level playing field with Singapore and other seats of arbitration. And they offer some very interesting potential approaches to fee arrangements going forward. So with that, I'll stop and say thank you very much for your patience.
Thank you, Everett. Thank you for the very wonderful sharing and advice. Now I think we can move on to the question and answer session. I can see that there are a number of questions. Everett, can you see the chat box? I think there's one question from Eva asking, if a Chinese mainland lawyer reached an ORFS agreement with his or her client and the seat of arbitration is Hong Kong, then can the tribunal appoint the course according to the new Hong Kong ORFS regime? Can you answer this question?
Yeah, so I think that there'll be a question. I think the first question will be, is the type of outcome-related fee structure agreement that the mainland Chinese lawyer wants to use allowed under the regulatory regime that the mainland Chinese lawyer is subject to? Because it may well be that even if that the outcome fee arrangement is allowed in Hong Kong, that lawyer, if they're subject to mainland China lawyer professional rules, may be prohibited from entering into that specific arrangement. So there's a sort of threshold question of what's allowed under the mainland Chinese system, and I am aware that certain outcome-related fee structure agreements are allowed in mainland China. So if it were one of those structures, then I would see no reason why a mainland Chinese lawyer would not be able to enter into that type of arrangement with their client for arbitration that was seated in Hong Kong, provided, of course, that arrangement also complied with the requirements in Hong Kong, which I've just gone through in this seminar. Does that answer your question? I hope that answers the question. If there's any clarification needed, Simon, please feel free to ask. Yeah. But I think, in short, the answer is, in theory, yes, it would be possible for a fee arrangement to be used in this type of situation.
Okay. And the second question from the audience is, Section 19.8 is that B of the ordinance stipulates that a reference to an ORFS agreement is a reference to an ORFS agreement made on or after the day on which divisions 3, 4, and 7 have come into operation. Given that the division 3, 4, and 7 have not come into force yet, so if now I reach a ORFS agreement with a Hong Kong lawyer, then this agreement is void? This is the question from the audience.
Yeah, so I believe it would be void. And even if it were not void, I think it could create a lot of problems for the Hong Kong lawyer, because as of now, as I understand it, it's still prohibited to enter into these types of arrangements at all. So until the regime fully comes into force later this year, Hong Kong lawyers should not enter into these types of arrangements.
Okay. And another question from Chin Ki Tang. What are the typical arrangements contracts client lawyer makes with third-party PE funder?
So as I mentioned in the presentation, so third-party funding is now allowed in Hong Kong, and it's quite, I think it's sort of almost a different presentation in itself to try and explain the exact relationship between and the type of contracts that we entered into between an arbitrating party and a third-party funder. But I would say that there are some very reputable funders operating in Hong Kong, like Omni Bridgeway. So if you were to look on the Omni Bridgeway website, for example, or feel free to email me after this presentation, I can point you in the right direction to find some material explaining how third-party funding works in Hong Kong.
Thanks. The next question from the audience. What if a party wins, but the award is unenforceable for some reasons, for example, public interest, or the losing party goes into liquidation? Would the lawyer still be entitled to upside? If so, would he claim against his client?
Yeah, this is a very interesting question, and it depends upon the precise terms of the CFA or DBA. But in theory, you could have a situation where the DBA, for example, provides that once you have the award, that's it, and even if it's not recovered against a party, the payment is still due. So there could be some difficult situations where a client doesn't actually enforce the award, but the money is still due to the client. The money is still due to the lawyer.
Okay. And the next question is from Lydia. First of all, many thanks, Edward, for the informative and very helpful presentation. My question is, are the ORFS considerations or models also applicable for litigation? And if yes, to what extent? And when they are definitely not acceptable for the litigation procedures?
So the answer to that is that outcome-related fee structures under the current Hong Kong reforms will only be permissible for litigation proceedings that concern arbitration. So, for example, an application to the Hong Kong court to challenge an arbitrator, or an application to the Hong Kong court to enforce an award. For those types of court proceedings that have a direct link to arbitration, outcome-related fee structures can be used, but they can't be used for Hong Kong High Court proceedings unrelated to arbitration. And that's actually a slight distinction from the position in Singapore, where at least in Singapore, for Singapore International Commercial Court cases, CFAs will be allowed, even if they have nothing to do with arbitration. But for now in Hong Kong, you can only use outcome-related fee structures in Hong Kong litigation if they're related to arbitration.
Does it also apply to application to set aside an award?
Yes.
Or
yes.
taxation
Yes, you should be able to use it for an application to set aside the award as well.
Yeah, thanks. Next question. Is the case name of the cost disputes of Voltaria Theatre? That's the case name. I'm trying to find the judgment online to know why these law firms CFA exceed the cap. I'm not sure if you know this case. Or...
Yeah, it certainly is. This case certainly involved Voltaria Theatre, and the Global Arbitration Review article, which I haven't looked at for a few days, explains in quite a lot of detail why this situation arose in terms of the CFA exceeding the cap. And I think it was quite an unfortunate set of circumstances, and lots of observers have felt that the law firm was put in a very difficult position. So if you have access to Global Arbitration Review, you should be able to find the article there.
Now this is the last question from Paul. Does this new regime allow lawyers to stipulate that they have a say or even a decision in settlement offers made to the client?
Hi, Paul. Good to hear from you. So I don't think this is expressly dealt with in the ordinance itself, but it could well be something that's addressed in the subsidiary legislation, or I imagine there'll be some guidance that the Hong Kong Law Society will issue on this, because Paul's right to raise this as an issue, because it's something that can create quite a lot of discussion in the context of third-party funding.
Okay. Let me see if there's any other question. I think this is the last question. Okay. So with that, is there any other question? If not, we shall conclude our seminar today. No more question? Okay. And with that, thank you very much, Edward, and thank you everyone for attending today's seminar. And I think that's all for now. Have a good day. Bye-bye.
Thank you very much, everyone. I hope that was helpful. Bye-bye.
Thank you. Thank you, Edward. Thank you, everyone. Bye.